a 2-count complaint, but only one is the subject of today's hearing. That's weapons, taser, possession, or sale of. Counsel, is there any resolution in this matter?
Yes, Your Honor. If the court will accept a plea, essentially as a lesser included to illegal transport of a firearm, the people would offer to dismiss the charge count if the defendant would plead guilty to that. Additionally, the people would be recommending a 6-month delay of sentence with full dismissal if the defendant is compliant with terms of the delay.
How do I get from a taser to a firearm?
I know it's not the same thing, Your Honor. Ms. Carey has said she has used this to resolve taser cases in the past. I respect the court's decision on whether it's willing to accept this.
Mr. Harrison?
I had similar concerns, but being mindful of the fact that we do wish to resolve this case and that both the prosecutor and I are comfortable with there being a misdemeanor resolution of the case. I guess it kind of goes back to what I often describe as the good old days when we were allowed to plead 4-year drug possession cases when the substance in question was in fact methamphetamine. But that was kiboshed due to the, I think, a strict interpretation of the statutory language. I would also note that in this instance, it does appear that the licensure requirement, the CPL requirement, has been extended to tasers in Michigan. For example, if you're a licensed CPL and your weapon is in the car when you're pulled over by law enforcement, you are required to disclose that to him.
Has that passed? I know there was a.
That's as far as I looked it up this morning, and that is the law, and that does include tasers.
When did that pass?
I don't know.
I knew there had been a proposal, but I hadn't heard that is.
I gave you the site, Nate. What was it? Oh. Perfect opportunity to steal it from the squad. It's 28.425F. Let me grab it too while we're sitting here.
So while we're discussing this, are we aware, are there any other prelims running this afternoon?
I believe Ms. McNamara's case will be a prelim.
I don't think you think very long.
And so the proposed agreement is improper transport, is that?
Transporting or possessing a firearm in or upon a motor vehicle. That is MCL 750.227D.
That says.
Did you say 227B?
D.
Oh,
sorry.
D.
D is in dog, Your Honor. I'm sorry.
That doesn't have a different. Right. I'm looking at 28.425F that this time I accessed directly from the MCL website. It does show an amendment that was effective in 2015.
Yeah, I see that. I think I'm thinking of a different.
And just so we're sure, let me read the paragraph 1 an individual who's licensed to carry a concealed pistol shall have his or her license to carry that pistol in blah, 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 possession. At all times, he or she is carrying a concealed pistol or a portable device that uses electromuscular disruption technology. That is different than the one I looked at, just the general search website when you type in MCL 28 425F. So I believe that electromuscular disruption technology is a new addition to the statute. It's not the one that we're seeking to enter the plea under, but I think it's analogous to it.
I still struggle with how we go from a taser. I mean, she's got to swear to tell me the truth. And we're going from a taser, an alleged taser, to a firearm. I don't understand, because it's not a lesser included.
Your Honor, I just assumed it would be sort of like with plea people to allow another to operate, even when it's them operating or.
At least there's an operation of a motor vehicle, right?
Yeah.
This, I've got a taser versus a firearm. In order to do it, she's gonna have to make up an entire untrue factual basis to accept the plea.
Unless we do. Okay. Yeah, Your Honor.
Your Honor, I think we'll try a different delay of sentence involving a taser upstairs.
Which
I should give, I should give.
I do, but I want to give it to you.
Yeah. There you go.
Mr. Harrison, do you want to talk to her now about that? Do you want to talk to her after you're done with
If
some
you'll
prelims?
indulge me for a few,
I can,
can't get it resolved.
yeah, I'll give you a couple minutes.
Thank you.
Mr. Hartel, what case do you have?
Mindy McMahon on the misdemeanor portion, Your Honor.
Is there any resolution in that case?
There is not, but if we could address bond, I would appreciate it. I believe Mr. Carnes would waive the formal notice requirements.
I did get notice of this motion yesterday, Your Honor, since I did have advance notice. I'll waive the remaining 6-day notice.
All right. Court calls 252951 OT. People of the state of Michigan versus Mindy Sue McNamara. The PR bonds.
Free trial, final free trial.
Mr. Hartel, the file that you represent her on has a PR bond.
Well, all right, Your Honor. For some reason, my client and I and my Councilman Sedgwick thought there was a monetary bond on this one as well.
Monetary bond is on the felony file, not the misdemeanor file.
Well, in that case, I don't have any arguments to be made if it's a PR bond, because that means you could go to treatment on this file without that. But I don't know if the court wants to address the final pretrial portion of the case in any fashion. Or if the court's willing to hear both sides, but I'm sure Mr. Harrison would be fine with making those arguments.
I am.
For what?
Oh, for the felony portion as well, we had filed motions in both.
You mean for the bond?
Yes, Your Honor. If the court's not willing to do so, I fully respect that.
I guess where he's the attorney of record and he's here, I would prefer that he handle that.
I would
Request for
completely respect that,
bond.
Your Honor.
But I guess in regards to the final pretrial, today is the final pretrial. So there's no resolution in this case.
There is not, Your Honor. That's what it is. She doesn't have me here.
All right. And have the parties, I'm assuming at this point, because this case has been going on since July, have exhausted all their possible negotiation in this?
Yes, Your Honor.
I would agree, Your Honor.
All right. And so it looks like the next step is trial. Ms. McNamara, do you understand that today is the last day I will accept a plea in that case? From here on out, I will not accept any pleas.
Your Honor, upon sidebarring with my client, she's actually willing to plead as charged on that. I apologize for any confusion upon the court.
Mr. Carnes, I assume you have no objection to that?
No objection, Your Honor.
All right. Ms. McNamara, is that how you wish to resolve this case?
Yes, Your Honor.
Please raise your right hand as best as you can. You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
It's my understanding is your intent is to plead guilty as charged to operating without security. That is a misdemeanor punishable by up to 1 year in jail and or a fine of not less than $200 nor more than $500. Is that your understanding of what you're doing today?
Yes, Your Honor.
Has anybody promised you anything in order to get you to plead today?
No, Your Honor.
Has anybody threatened you in any way? And is it your own free choice to plead today?
Yes, Your Honor.
Do you remember reading and signing this advice of rights form, talk about your rights to an attorney and rights to a trial?
I do, Your Honor.
Do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right? You won't have a trial of any kind?
I do, Your Honor.
Back on July 1st of this year, were you on probation or parole?
No.
Were you on bond? So the felony file came about on August 19th.
Yes, I was, Your Honor. Maybe, I'm not sure.
On July 1st, were you on bond in any other file?
No, Your Honor.
All right. Counselor, are either of you aware of any other promises, threats, or inducements?
No, Your Honor.
Ms. McNamara, then to the allegation that on or about July 1st, 2025 in the city of Cadillac, Wexford County, how do you plead to operating a motor vehicle without security?
Guilty, Your Honor.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on July 1st, were you the owner of a 2001 Volkswagen Passat?
No, I was not, Your Honor.
Were you operating that vehicle?
I was, Your Honor.
And was that in the city of Cadillac?
Yes, Your Honor.
Did you have police interaction?
I did, Your Honor.
And did that motor vehicle have insurance?
No, it did not, Your Honor.
Did you know that it didn't have insurance?
I did not, Your Honor.
Counsel, I can't accept the plea.
I respect that, Your Honor. We would ask this to move forward to trial.
Ms. McNamara, through, it's no fault of your own, just based on what you've told me, there's certain facts that have to be met, and from what you've told me, I can't accept that plea because of that. So it appears, I see Mr. Carnes is looking at his file.
Your Honor, the report is silent as to whether she knew. I'm just going to dismiss the case based on that.
All right, based on that, I assume that's with prejudice.
Yes, Your Honor.
Ms. McNamara, what that means is Mr. Carnes is going to dismiss this case with prejudice, which means it cannot be brought back. All right. For the record, Mr. Harrison, I just signed a waiver on Ms. McDade, is that correct?
Yes, that's correct.
All right. So now that brings us to Ms. McNamara's felony file.
Indeed.
Case number 254091 FY. Francis Counsel.
Nick Carnes on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mindy McNamara. She's joined me at the table.
And we are here for a preliminary examination on a one-count complaint of home invasion second degree. Is there any resolution in this case?
There is none.
All right, Mr. Harrison, I understand you intend to make a motion for bond at some point.
I do, prior to if the determination of the court is that the case is dismissed, however.
I understand. We'll take it up at the end of it.
Thank you.
Prelim. Mr. Carnes or Mr. Harrison, any preliminary matters?
No.
Um,
Your first witness, Mr. Carnes.
Your Honor, just to be on the safe side, I am going to sequester my witnesses. Your Honor, the people call Stephen Nicholson.
Sir, before you have a seat, will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? All right. Go ahead and have a seat. Mr. Ingleson, everything we say is recorded, so I'll need you to speak right up so we can make sure the recording equipment can hear you and the parties can hear you as well, all right? And whenever you're ready, Mr. Carnes.
Thank you. Sir, can you please state your name and spell it for the record?
Stephen Ingleson. Stephen.
Thank you. Where do you live? And what happened on your house on August 19th of 2025 that brings you into court today?
This guy named Darren come up and was talking, I was out working in my yard. Apparently, maybe his girlfriend went into my house and bought him.
Mr. Ingleson, the recording equipment's not picking you up, so I need you to speak up, please.
Do you need him to repeat that?
Were you able to get his address?
August 19th of 2025, and try to speak louder this time.
I was working in my, in front of my garage. That's where I was. And, this guy came up, Darren Long came up to me and started having a conversation with me. And while he was keeping me busy with this conversation, his girlfriend ran into my house, which would be where I couldn't see.
Objection, Your Honor.
So,
Objection,
Oh,
he's
hold on.
clearly not testifying from personal knowledge. He
Mr.
just said he
Carnes,
couldn't see her.
I got it, Mr. Harrison, Mr. Carnes.
Mr. Ingelston, I only want you to tell me about what you saw. Don't tell me about anything anyone else told you later. We'll have those people come in and testify, okay?
The objection is sustained.
After speaking to Darren Long, what, if anything, did you notice?
And then my front door had been open. My house, inside my house, cupboards were open. My bedroom doors were open, dresser drawers for my clothes and stuff, and kept other things in there, too. It was my personal stuff.
Mr. Ingersoll, I really need you to speak up. The recording equipment is not getting you. So that microphone doesn't amplify your voice. So I need you to yell, talk as loud as you can.
I'm sorry, I had a issue with my door.
I understand.
I could hear him clearly. If defense doesn't object, I would just place on the record that he noticed his front door was open, that cupboards were open, and that dresser drawers were open.
Mr. Harrison?
That's consistent with my observation.
All right, thank you.
What else, if anything, did you notice in your home?
My phone was missing. Staying on the coffee table.
What, if anything, else was missing?
Out of my strong box. And, tax money, let's say. Collectors, baseball collectors. I don't know what they're really called. They weren't mine. I was just storing them for some reason.
Okay. What were they? You said baseball collector.
Yeah, bonds. Diamonds.
What color was the strong box?
All right, we're going to take a quick recess. The recording equipment is not picking him up. So I think what we're going to have to do is we're going to have to adjourn until we can find a way to amplify his voice. Whether that means we have to bring in some sort of karaoke machine, I don't know, to amplify that. But we're just not getting a clear record, and we're going to need a record, so. So I find for good cause today that we're not able to complete the preliminary examination, and we will adjourn it till next. Of course, we've got like 14 piled up next week. Does that go to the recording equipment? I mean, he's on top of one right now.
I think that goes to the poly.
That's the
Oh,
Polycom, yeah. All right. So I think we'll have to adjourn, and between now and then, the court will come up with a different amplification system. Mr. Harrison, I understand that you're still going to want to address bond.
Indeed, Your Honor.
For purposes of the preliminary examination, I find there's good cause to adjourn. We'll reconvene next week. Mr. Ingelston, it's no fault of your own. It's just your voice is so soft, the recording equipment just is not picking you up. So I need to come up with a way to be able to amplify your voice to carry it to the recording equipment. Okay?
Your Honor, I do have another witness here today. I wonder if we could start with him and then do a continuance with Mr. Ingelston, just to save Mr. Stewart another trip back.
We can do that. We can reconvene next week to complete it. Yep.
Okay.
All right.
Thank you.
All right. Mr. Ingelston, you are free to step down. Is he okay to leave?
Yeah, yep.
You'll be probably called back on a different date. Okay? All right. You are free to leave. Thank you. And thank you for that, Mr. Carnes. I didn't mean to steal your thunder there.
So, Your Honor, I'm going to call Mr. James Stewart.
Mr. Stewart, if you can make your way through these two half walls and come up to this chair beside me. Before you're seated, if you'll raise your right hand, you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
Yes, sir, I do.
You may have a seat. And whenever you're ready, Mr. Carnes.
Thank you. Can you please state your name and spell it for the record?
James Ustle Stewart, JamesStewart.
And where do you live?
901 Far Street, Cadillac, Michigan.
What happened near your house on August 19th of 2025 that brings you into court today?
There was a couple walking down the sidewalk in front of my apartment. They were heading northbound towards my neighbor Steve. There was a guy and a girl that were talking. They got down to the fence. Guy came across Steve's front yard, went to the side. Steve was outside working on scrap metal. The girl went inside Steve's house. He was in there approximately 2 to 3 minutes. She came out. She went around the corner by the bush, around the corner. Came back. She went back in the house the second time. The guy was still outside talking to Steve. He was in the house 5 to 6 minutes. This time she came out and she was carrying something black. I couldn't identify it. She was too far away. That's what I saw.
Were you familiar with these two individuals?
Yes, I've seen them on the block. I've been there 10 years.
Do you know their names?
Yes, I do.
And what's the male's name?
Catherine Long,
And what's the woman's name?
Mindy McMahon.
Do you see the person you know as Mindy McNamara in the court today?
Yes, I do.
Can you tell me where she's seated and something that she's wearing?
Just sitting over here wearing orange.
Your Honor, may the record reflect the witness has identified the defendant.
Mr. Harrison.
I don't have an objection.
It shall so reflect.
I understand you were, well, how far were you from, you said Steve. Do you know Steve's last name?
I really don't know Steve that well, other than my neighbor. He has tools down there, and like I said, he scraps. I work on my motorcycle and I need tools. He's so close. I've known Steve for 10 years, but I've only been down there a dozen times in 10 years. I don't hang out with Steve.
Do you know Steve's address?
No, I don't know his address.
Okay. What was Darren Long doing while defendant was going in and out of the house?
He was talking to Steve. I don't know what he was talking about because I wasn't down there. He was wearing a backpack. He had a backpack on. After all this had taken place, Mindy went around the corner and left. He came back across in front of my view, going southbound, going to his dad's house, which he lives 2 houses from me across the road. Approximately 45 minutes later, Mindy showed back up over there at his dad's house.
How far is Steve's house from where, I should, hold on, let me ask this first. Where were you when you saw all this happening?
I was standing in my front door of my apartment.
How far is Steve's house from your front door? So I understand you're 75 yards away. You described defendant walking out as carrying something black. Can you describe that thing any more than just it was black?
She had it in her left hand, would be my view of sight. Couldn't make out what it was. I don't know what was in her hand when she went in there. She didn't have anything in her hand.
Thank you, Mr. Stewart. I don't have any other questions for you. Mr. Harrison might though.
Mr. Harrison?
At one point you testified that you were too far away to give any distinguishing information about this black box. You remember saying that?
Never said no black box.
You said something that she was carrying something?
Yes, I
Black.
said she was carrying something black, but I didn't say no black box.
Okay. All right. I'm not gonna put words in your mouth. I want to have an accurate record here, okay?
Sure.
She was carrying something black that you couldn't identify because you were too far away.
It's too far away to identify what she was carrying, yes.
Okay. Again, I'm not trying to mischaracterize your testimony, so please correct me like you just did. And you were able to, despite that distance, you're positive that that was Mindy McNamara you saw that day?
Absolutely positive.
Okay. And you'd seen her, what, regularly around that neighborhood?
I've been there 10 years and I've seen her up and down with this Darren numerous times in arguments, in just total chaos.
Okay, so does this Darren Long, does he live on Far Street?
From my knowledge, he lives with his father, yes,
Okay, so his father lives on Far Street,
yes,
and that would be on the same side of the road as Steve's house?
yes,
Okay. You've noticed Mr. Long coming and going from that residence.
yes,
You noticed the person that you've identified as Mindy McNamara going from that residence.
yes,
Have you ever been formally introduced to Ms. McNamara?
never.
How is it that you know her name?
It's on my paperwork,
Okay. Did you know her name before you quote saw your paperwork?
yes.
How did you know her name before you saw your paperwork?
I heard it through the neighborhood,
So somebody in the neighborhood identified a person walking through your neighborhood as having the name Mindy McNamara, and that stuck with you.
no, that's not how it came about.
Okay. It was just something that you would deem to be common knowledge in the neighborhood?
I wouldn't know that either.
Okay, so Mr. Long didn't tell you what her name was, did he?
No, I'd never talked to him before in my life.
Okay, so you've never met Darren Long either,
Never,
but through the same unexplainable mechanism, you also know his first and last name.
yes,
Okay. And is this a regular activity that you do? You stand out in your yard and just enjoy the
I wasn't standing
weather?
in my yard, I was in the house looking out the window,
You were looking out the window, okay.
the window in the front door.
Okay, so you're looking out a window and your front door at a location on the other side of the street, which you've self-described as 75 yards away?
Yes,
Okay. And you said you saw the person that you've identified as Mindy McNamara. I'm not gonna take issue with you on that. Go into Steve's house. She'd go in the front door,
she went in the front door, yes, sir,
right in the front door.
right through the front door.
Got it. Okay. Are there other doors to Mr. Ingelston's house? You know who I mean? I mean Steve, right?
Yes, I know him by Steve.
Okay. On his house, are there other doors?
Yes, there's a door through the garage entry into the house. And
Okay.
there's a front door. I don't know if there's any other doors in that.
Okay. Do you have to go into the garage to use the other door?
You have to go through the garage to use the other door. Explain yourself.
I wonder, you said there was a garage entry door or some words to that
There's a
effect.
garage entry door where you go through the garage entry door. When you're inside the garage, there's another door that gets you into the
I
house.
got you. Okay. All right, I understand now. But that's not the door that this person used. She used the front door.
I stated she went through the front door. I seen her go in the front door twice. Yes,
Okay, and that's the person that you believe to be Mindy McMahon.
it is Mindy McMahon. She's sitting right there.
Okay. All right. You said, and I want to make sure I got this, that you live at 901.
Mr. Carnes,
No further questions, Your Honor.
may this witness be excused?
Yes, sir.
Mr. Harrison,
I have
Any
no
objection?
objection to that.
permanent or temporary?
Permanent.
Sir, you are free to go about your day. Thank you for being here today.
Thank you, Your Honor.
Thank you. Mr. Carnes,
The people have no more proofs today, Your Honor. We do ask to keep the preliminary examination open.
all right. We will adjourn the prelim then to a later date so we can get a way to pick up Mr. Engelson's testimony. And that brings us to Mr. Harrison's bond request. Mr. Carnes, any objection to hearing that today?
No, Your Honor, I did receive advance notice as of yesterday, and I received the supporting document. which I reviewed.
Was there a motion filed in this when you say advance notice, or was it just?
No, Your Honor, it was just an email that I received from the
All right.
defendant's office.
And Mr. Harrison, you did not file a motion, is that accurate?
I believe that's an accurate statement, Your Honor. I believe that frankly, I believe that's still a work in progress. I have not been sufficiently physically present in my own office of late to verify that. And I don't see a written document in our electronic file either. But at any rate,
Having no objection, go ahead, Mr. Harrison.
yes, Your Honor. We would simply make a couple of requests that I think are fairly straightforward. First and foremost, she lacks the financial resources to pay the current bond. So it would behoove us to at least have the court consider a reduction in her bond to a more reasonable figure that she could pay, which would include at this juncture, I suppose, a PR consideration as well. Secondarily to that, she has secured a spot at a rehabilitation center called Great Lakes Recovery Center. That is the supporting documentation we provided to Mr. Carnes. That also is the basis for a written motion, which, as we determined, is yet to be filed with the court. And that indicates that she could come to their facility and begin her treatment as of the 22nd of October at 1 p.m. We don't want her to miss this opportunity. Obviously, a person that's in the throes of addiction or has issues with substances, it affects every area of their life, including their ability to frankly participate in their own defense in a case such as this one. So we would encourage the court, I understand that the court would like us to submit some written submission containing that verification, perhaps by stipulation or even a motion based on stipulated facts at that point. We would be happy to do that, Your Honor, but that's the two-pronged attack that we have here, is that we would seek a release to treatment for her. Ideally, that would be through a PR bond with the usual conditions regarding treatment, including but not limited to community corrections supervision, their verification, and their ability to continue to verify her attendance in the program. And not, in no small measure, it would also include a demand that she return to jail if she fails to complete the program or is terminated for any reason while attending that facility. Again, frankly, I would expect the court to say something along the lines of, I'm amenable to doing that, submit an order that has all the details and have Mr. Carnes look at it first. I'd be happy to do that.
Mr. Carnes?
Thank you, Your Honor. This is a serious case of home invasion. Second, I guess in that sense I oppose it, but I'm also aware
that Ms. McNamara has relatively little criminal history. And certainly from where I sit, it seems she has a serious problem with methamphetamine. I'll leave this in the court's decision-making process. I vehemently oppose any release, any reduction in bond unless it is directly from jail to a treatment facility. I don't think it would be safe to release her, given this, other allegations that I can't prove regarding property crimes, as well as a history of domestic violence allegations. So again, I'll just leave it in the court's discretion as far as what is the best thing to do. Again, this is a home base second, so it's very serious, but we do have a defendant with limited criminal history. I think all of it fairly recent. Thank you.
Mr. Harrison, any rebuttal?
No, I frankly, I disagree with much that he said, in all honesty. I thought it was cogent.
What, so I have nothing showing me she's addicted to methamphetamine. What do either of you have? I mean, there's no drug convictions in her past,
Right.
other than maybe a marijuana case from out of state. This is a B&E case. It's not a drug case.
Right.
So
Go ahead.
Similar B&E allegations that frankly there wasn't enough evidence to prove, but lots of people talking about her and Mr. Long.
is that the one that, I'm sorry, go ahead.
That's who was testified about at today's preliminary examination. As well as just reading through reports between Ms. McNamara and Mr. Apsey. Mr. Apsey regularly talking about his methamphetamine addiction and how Ms. McNamara is involved in that as well, I guess, as well as just known associates. In the no insurance case, there was an individual arrested with a backpack full of methamphetamine in that same case. So Ms. McNamara herself has never been caught with methamphetamine, but it is certainly my impression, just based on reviewing police reports, and especially reviewing when I consider this property crime, that it is indeed an issue.
I concur with that as well, Your Honor.
Mr. Carnes, the B&E that you were talking about before, so there's one showing dismissed of the 77th District Court. That's not the one you're talking
No,
about.
I'm talking about some storage units here. Back there was seen on video, but not clear enough to show that she was involved in the unit that was stolen. That wasn't on video. There were some broken into that way.
Mr. Harrison, anything further?
I don't, interestingly enough, Your Honor, Mr. Carn's depiction of the events in question is accurate. I don't mean that it's interesting that he got that accurately. I mean, we do see eye to eye in terms of some of the interpretations that he's made when he made that presentation in the court.
Well, the court is not convinced. There's no prior history of drug use. There's no allegations of drug use in this case. There may or may not be drug use because who she's hanging around with and who she may be in a car with. I realize that she has been accepted, but from where the court sits, it has been provided no evidence that she's a person in need of treatment. So I'm going to deny the request to release for bond or release for treatment services. And I'm also, to the extent that there is a request to adjust the bond to a lower amount from the 5,000 that was previously set, based on what I've heard today so far through the preliminary examination, I do find that Ms. McNamara is a threat to the community. So I am going to keep the bond as originally set.
So
Ms. McNamara, I suggest you contain yourself, otherwise you could find yourself in contempt of court. Mr. Harrison?
I'm trying to get the screen up. That's $5,000 cash or surety, correct?
Correct.
Oh, another wrong file, Your Honor, I'm sorry.
Anything else?
Yes,
Ken?
okay, I see it now. Thank you, I'm sorry.
Anything further?
Nothing, thank you.
We are adjourned. Thank you. Court next calls the people of the state of Michigan versus Mark Ronald Kraft. This is case number 253682 FY, appearance of counsel.
And I'm Jeff Harrison, I'm here on behalf of Mr. Kraft. He's joined me at the table for court here today.
And we are here for a preliminary examination on a four-count complaint of non-sufficient fund checks, $500 or more. Is there any resolution in this case?
There's not, Your Honor, but people are gonna request another adjournment, and I do so reluctantly, but Mr. Harrison provided information to me yesterday afternoon that I think needs to be looked into and investigated. We did subpoena the bank to be here today, and they are not here. So, but while I was sitting here, I had the bank records emailed to me, but obviously I'm not provided them to Mr. Harrison. So I think based on that, really, the new information needs to be looked into. Could also be case determinative. We have been working on this pretty diligently for 2 weeks.
Yeah.
And trying to get records and things like that. So, but the new information has also put a new twist on it. So
How much time do you think you need in this hearing? If we went to the 28th, do you think that'd be enough?
I would certainly hope so.
I think that's a good approach to take, Your Honor. For example, I did receive some information this morning or yesterday, or maybe it was even on Friday. It's in a zip file that my computer doesn't want to open, so I'm gonna have to have help with that as well. And it may be the same or similar information that Mrs. Carey is taking from the bank, so I really don't feel as though we're in a position to move on the case, unfortunately.
Court will grant the request for the adjournment by what sounds like stipulation. Mr. Kraft, I have a question for you. We received some return mail addressed to
It's still Nancy.
all right, as stated, based on the stipulation of the parties, we will adjourn the preliminary examination until October 28th. Just a condition, just a reminder, Mr. Kraft, that any bond conditions that you have continue. You can go out to the front window where you checked in and get a copy of your next court date.
Thank you.
Thank you, Your Honor.
We get a hold of Mr. Niegos in the jail and get Mr. Du Bois
Yes.
on the Polycom. Yeah.